The International Jurists Award 2010 also goes to Professor Shimon Shetrit, Professor International and Public Law, Hebrew University of Jerusalem. This award is being presented to him for maintenance of the highest standards of legal education. He has played a seminal role in improving the educational system to cope with the increasing complexity of legislative and regulatory framework and the challenges posed by a shrinking world. We shall now pose for a group picture with the recipients of the International Jurists Award 2010. Thank you. May I now request Honourable Lord Sir Justice Mark Potter, former Head of Family Justice for England and Wales, to address the gathering, please. Here. Mr. Mark Potter to speak.
Justice Balakrishnan and fellow justices and jurists, I was delighted as the representative of Lord Chief Justice of England and Wales, Lord Judge, to receive the award of this conference for his contribution to the administration of justice on his behalf. I should like, if I may, to convey his very great regret that he is unable to receive it in person, and to express to the conference in his own words his gratitude for the high honour which it represents. It's only the extremely pressing, and as I can say, though he would not, the arduous and burdensome nature of his duties in the United Kingdom which have prevented his attendance. He's asked me particularly to say that he has long admired the contribution of the judiciary of India, and particularly the decisions of the Supreme Court, in upholding the legal and human rights of Indian citizens in a number of what may be described as tough and imaginative decisions, which have on a number of occasions succeeded in deriving specific and practical human rights, including rights to environmental protection, from a constitution framed in broad terms. Now, we live, of course, in an age where there's an increasing national and international recognition of certain fundamental human rights, a number of which are embodied with a greater or lesser degree in many of the by the constitutions, the domestic constitutions of many of the major states in the world, as well as in various international treaties and other instruments to which most of such states are parties, including, of course, the United Kingdom. One starts with the United Nations Universal Declaration of Human Rights in 1948, and proceeds, so far as the UK is concerned, to the European Convention on Human Rights, now incorporated into English law by our own Human Rights Act 1998. This has raised the necessity for our courts to examine closely and afresh the adequacy and the boundaries of a number of the rights and liberties hitherto recognised only in common law as freedoms within our unwritten constitution. In the face of the increasing threat of terrorism worldwide, and in particular in the United Kingdom, a number of those decisions have related to the treatment of those suspected of terrorist activity, and the extent to which they may be detained and tried or deported for their activities, or otherwise controlled by methods and measures which fall short of the standards traditionally observed in our normal criminal processes of arrest, detention and trial. This is, of course, a problem facing all the great common law jurisdictions across the world. In this connection, so far as the UK is concerned, the lot of presiding over the House of Lords in a number of difficult cases fell to Lord Bingham of Cornhill, Lord Phillips, our present senior law lord's predecessor. And many of those here today will, I'm sure, have learnt of Lord Bingham's recent death after only a short illness, early in his retirement and still at the height of his powers and activities. It's a tragic loss to the world of jurisprudence. And in this respect, Lord Judge has asked that I should say a few words about Lord Bingham, and in particular about the institution which has only recently been formed in his name under the auspices of the British Institute of International and Comparative Law, and which may yet be unknown to this audience. It's called the Bingham Centre for the Rule of Law. It will take as its starting point and be based on the content of a book published earlier this year, simply under the name Tom Bingham, and entitled The Rule of Law. It's a book which has not only been widely applauded among lawyers, but also is an articulation for the intelligent layman of the ingredients and importance of the rule of law, as that phrase falls to be redefined in modern conditions. It remains based on the concept made famous and elaborated by Professor Dicey, who first used the phrase the rule of law in his book, An Introduction to the Study of the Law of the Constitution, in 1885. And Tom Bingham's work has been described by our Prime Minister as prescribed reading for his ministers. Dicey identified three aspects of the rule of law as he perceived it in the common law tradition, namely the supremacy of the law over government power, equality before the law, and enforcement before the courts. Civil law tradition had generally focused less on the judicial process and more on the nature of the law-based state. Lord Bingham has encapsulated the core of the idea of the rule of law as being that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered by the courts. He elaborates this into three short 8 principles. First, the law must be accessible and, as far as possible, intelligible, clear and predictable. Second, questions of legal right and liability should ordinarily be resolved by application of the law and not by the exercise of a discretion, ministerial or otherwise. Third, the law should apply equally to all, except to the extent that objective differences justify differentiation. Fourth, the law must afford adequate protection of human rights. 5, means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. 6, ministers and public officers at all levels must exercise the powers conferred on them reasonably, in good faith, and for the purpose for which the powers were conferred, and without exceeding the limits of such powers. 7th, judicial and other adjudicative procedures must be fair and independent. And 8th, there must be compliance by the state with its international law obligations. Now, these are the principles which separate the rule of law from rule by power and from rule by law, in the sense that having laws duly passed by the legislature doesn't itself mean that they in fact meet the requirements of the rule of law. For Lord Bingham, the protection of fundamental human rights was not simply an obligation imposed by statute or treaty, but by his profound belief in the wider concept of the rule of law. As I've indicated, other definitions of the rule of law have tended to be limited to procedural requirements rather than substantive protections. Lord Bingham's approach was that the rule of law includes justice in a substantive and not simply a procedural sense as one of its elements. So he included respect and protection for human rights as an essential ingredient of modern justice everywhere, including, for example, the right to a fair trial, freedom from discrimination, rights to participate in public life, and religious and cultural rights. He also regarded it as an important aspect of the rule of law that the state should provide the means for resolving civil disputes without prohibitive cost or inordinate delay, a problem which faces judiciaries in so many countries. Because, of course, unless these steps are taken, the realization of the civil rights can be rendered largely illusory. Now, the purpose of the Bingham Centre, which has as its first director the eminent, indeed world-famous constitutional and administrative law specialist, Professor Geoffrey Jowl, QC, who was until recently Professor of Law at University College London and the joint editor of the Smith's Judicial Review, is not simply to represent a lasting tribute to Lord Bingham, it is to carry on practical work to promote the rule of law as he sought to define it, not only in the UK, but worldwide. It's to provide a place for original research, analysis and discussion of the rule of law, those issues being discussed with practitioners, judges, governments, business, individuals, groups and organisations across all legal systems, including those in developing states. Now, there's no lack of need for such an institution in my own country. Despite the formal endorsement of the rule of law in our Constitutional Reform Act of 2004, we have since its passage seen our own violations or proposed violations of the rule of law. These include not only proposals for what are called Henry VIII clauses, which permit the substantive alteration of statutes after they're passed, simply by ministerial order and without further parliamentary approval, the latest of these being contained in the Public Bodies Bill now before Parliament. There have also been proposals considerably to prolong the periods of detention without trial of terrorist suspects and to deprive asylum seekers of the benefit of judicial review. Now, to be fair, it should be acknowledged that politicians have so far been dissuaded by the arguments of other politicians and lawyers that both of those measures would be contrary to the rule of law. In relation to asylum seekers, it seems likely that the limitations being introduced on the accessibility of legal aid in our country will radically reduce the level of applications in any event. But in relation to suspected terrorists, the matter is still under discussion by government and awaits governmental decision. It's now a year since Lord Bingham's retirement, but in that time the Supreme Court, which has succeeded the House of Lords in name but not in substance, breaches of rule of law on several occasions, for instance in respect of uncertainty in the determination of the period of a prisoner's sentence and the seizing of property of pre-listed terrorists without possibility or opportunity for legal challenge. These have all been censured and are examples of a situation where the rule of law comes into conflict with the supremacy of Parliament. Earlier this year also, the Court of Appeal struck down parts of the immigration rules for lack of legal certainty. I should just observe that in the United Kingdom at least, such violations of the rule of law are not generally cynical. They're usually driven by the natural inclination of those who genuinely consider it their duty to further the public interest. In the case of suspected terrorists, they're motivated by concerns for public protection, and in other more bureaucratic areas, motivated by the pursuit of the greatest good with the least interruption, hesitation or inconvenience. This inclination is naturally strengthened during times of stress, such as those which now arise from the threat of terrorism and the need to avert economic decline, both of which loom as the two greatest contemporary threats facing governments worldwide. In this respect, our government and our courts face in acute form the problem of reconciling the need for prompt and effective measures with continued observation of the rule of law in respect of individual human rights. So very briefly, what will the Bingham Centre do? It will first and foremost provide a forum for the discussion and the highest quality study of rule of law issues, such as I've already mentioned. It's intended that generally the study should be expert and fast and with a practical end in view. The method will be to discover whether a given measure or practice, whether enforced or proposed, accords with national or international norms, to ascertain what other countries do, and to suggest what the required principles of minimum standards should be, and to promote their implementation. Education and training will also be a natural byproduct of the work of the Centre as its knowledge base, expertise and resources develop. The Centre will use wide membership and contacts of the British Institute for International and Comparative Law among lawyers and policy makers to maximise the impact of the Centre's work. Whenever possible, it will seek to collaborate with other institutions and individuals, non-governmental organisations and researchers worldwide working here in the United Kingdom and abroad. Now, so far it has yet to approach the International Council